Here to talk about fraud and private equity is Jeremy Levy. He is with Pepper Hamilton. Nice to see you here.
Nice to see you as well.
How is fraud uncovered in the portfolio companies of PE firms, and why is the allegation of fraud sometimes just as serious?
It's a tricky question because in most cases, any allegation of fraud is going to be settled prior to litigation. So it would be before anyone is going to make a determination that fraud has actually occurred. So it's tough to say exactly how often it occurs. The key is the allegation, however, because when a buyer makes an allegation of fraud against the seller is going to have to, negotiate whether or not they're going to be willing to settle that claim. It turns out that it's actually really easy for a buyer to allege fraud under Delaware law, which is the most common law that's used in these contracts. All they have to do is plead the claim with particularity, which is just like saying the who, what, and where, and when, right? They have to identify somebody who has made a representation that would be false, and they have to say, where they made that representation and what they were intending to achieve. So it's a fairly low bar to establish that claim, which puts the buyer in a good position to allege fraud and put the seller in a difficult position to try and dismiss that case. The seller's usually not going to be able to dismiss that case before discovery, which costs a lot of money, and sellers really want to avoid that. So the buyer, just by alleging fraud, it's a pretty simple thing for the buyer to sort of recast a breach of representation as fraud. And so it puts the seller in a difficult position, and as a result, there are a lot of allegations of fraud.
So what about the actual examination of companies for potential fraud during the due diligence process? How is that rooted out?
Yeah, so what we do as deal counsel, we're consistently vetting the claims that the company is making and reviewing documentation, and we're working with the private equity firms and their outside advisors to establish the truth and veracity of what it is that the company is saying. But at the end of the day, the company is really in charge of the information that's coming to us. So if they're actually perpetrating a fraud, they can arrange the information. They can leave out information that would corroborate or reveal the fraud. And so we're really beholden to the information that they give us. And as a result, most fraud really isn't uncovered until after the buyer steps in, starts taking control of the company, digging around, and finding out the truth of the matter. So
what should the buyer be thinking about? What questions should they be asking you for their own protection?
Well, on the buy side, it's as I said, it's difficult during the diligence process to establish what any kind of basis for evaluating a fraud. I think what the buyers really need to be focused on is they need to think in their mind, what are the real assumptions, the real fundamental points of the real fundamental assumptions that they are relying on for their business thesis. Is there anything that the company is telling them during diligence, any answers to questions that they're getting, where if that representation or if that statement made by the seller was simply false, it would make the transaction no longer interesting for the buyer. The buyer would not want to proceed. If there's anything like that, then it's actually really important to get those representations into the contract itself, because under Delaware law, there's a line of cases that says that you can't actually rely on representations that are made outside of the contract to bring a fraud claim. Now, key there being that the seller's counsel has to draft the contract appropriately, because that line of cases, there's a lot of cases back and forth about whether or not there should be magic words in the contract. Recently, there's been a case that said that there shouldn't be any magic words, but then there was a case that said there shouldn't be a magic word, but there has to be magic perspective. It's kind of an unusual, murky area. But so long as seller's counsel is doing their job, it's going to be very difficult for a buyer to rely on one of these statements that was made outside of the contract for a fraud claim. And those statements are often very important. They could be statements about the pipeline, customers, contracts that are going to be signed. They can be statements about whether or not the projections are sort of concocted out of whole cloth. So there's a lot that often there's a lot of information that's shared between the business people. And if that doesn't actually make it into the contract, then as a buyer, you may not have anything to stand on.
What else might you tell me about structuring agreements for fraud protection? What other protections can these PE firms take?
Yeah, I think that's one of the more interesting things that has arisen in the recent years. There's a seminal case in Delaware that basically says no matter what you put in the contract, you can't shield yourself or limit your liability for an actual lie, right? And the case actually uses the word lying, because I think most people, when they think about fraud, and I think most people don't think about fraud, but when they are thinking about fraud, they're probably thinking that fundamentally someone must have told a lie in order for there to be fraud. And that's not the case. There have been a number of commentators who've pointed this out over the past few years. There are lots of different kinds of fraud, and they are somewhat less than actual lies. And so there's case law that says if it's an actual lie, you can't actually limit or shield yourself from liability for that. But for these lesser forms of fraud, you can. That's still open under the law. So one of the things that has been happening a lot more recently is that we're seeing a lot more agreements where people are defining fraud, especially on the sell side. When they draft the first draft of the contract, they're defining fraud. They're defining it to make it more like this actual lie so that they can limit the buyer's ability to bring a case in the absence of that kind of actual fraud that people are thinking about. On the buy side, we're trying to ignore that kind of thing, right? We're trying to say we want to leave the contracts sort of the way that they have been drafted for years and years, which is, lowercase f fraud is an exception to the indemnification limitations under this contract. And remarkably, I think, given the fact that there have been a lot of cases that have been coming out in recent years, the Seminole case is a pretty well-known case, there are still sell-side contracts that we see on the buy side that have this sort of lowercase fraud exception that allows the buyer to bring a lot of different types of claims that people probably weren't expecting.
So what changes do you think the PE firms and their counsel should make in their approach to deals to account for the current laws that exist?
Yeah, I think on the PE firm side, I think, oftentimes it's easy for a private equity firm to deal with counsel for a lot of years. That's a relationship that attorneys like, obviously. And so it's easy for private equity firms to sort of allow the lawyers to just handle the reps and warranties. And as I mentioned, it's important to make sure that if there are really fundamental statements or really fundamental assumptions that are critical to your business thesis, it's got to be in the contract somewhere. And if we haven't been party to those discussions, then we're not going to know what we need to add. So I think private equity firms need to think a little bit more about what the fundamental elements of their business case are, and make sure that those things are involved in the contract. And then I think, as I said, since there are certain things that Delaware law says that you can't actually negotiate, they're just prohibited for public policy reasons, I think we need to shift the conversation on fraud a little bit to those areas where we can actually, where there is room for negotiation. What are the different types of fraud, and should there be liability, or should there be any limitations on liability for those types of fraud? Is there anything, are there any other limitations that we want to impose, based on representations, who can make them, those sorts of things. And I think, some of those things private equity firms might really, really care about. I mean, private equity firms, as you know, have these, grids of their preferred terms sometimes, and, some of these might actually fall into that category, and I think that's usually not the case. From a counsel's perspective, we just need to do a better job, helping our private equity firms make those kinds of decisions. We need to frame the conversation the right way, make sure that they understand that there are limitations to what we can accomplish for them in the contract, so that they can understand what those limitations are. And, especially in scenarios where you've got multiple sellers, or you've got a private equity firm that's very much in the background, and the operating company sort of operates on its own, we need to just make sure that everyone understands what the sort of parameters are, what the rules of the game are, and make sure that we're all on the same page.
Some good advice. Jeremy Levy, thanks for your time.
Thank you.
I'm Rhonda Schaffler with The Deal.